In America, when it's time to hire a lawyer, most people ask the same questions. How experienced are they? What is their reputation? What's their track record? But before any of that, before the calls, before the consultations, there's one question that comes first. How much is this going to cost me? Because here's the thing, filing a lawsuit isn't just a legal decision. It's a bet, a financial gamble, dressed up in legal paperwork. And most people assume they already know how that bet plays out. You win the case, and the losing side has to pay your lawyer's fees. Simple, fair. That's how it works across the pond in places like the UK. But America doesn't play by those rules. Now imagine you're the one in that position. You believe you have a strong case. You know deep down that you've been wronged. But pursuing it? That could mean thousands of dollars in legal fees, with absolutely no guarantee you'll see a dime back. So what do? Do you walk away from justice because you can't afford to fight for it? For most people, that fear alone is enough to walk away, before the case even begins. And that's exactly why different fee arrangements came into existence in the first place. Not as some legal formality, but as a solution to a real problem. Clients needed a way to access justice without risking everything. Law firms needed a way to take on that risk and still survive doing it. If you're wondering how lawyers get paid in America, the answer is, it depends. It depends on the lawyer, the client, the type of case, the state you're in, sometimes even the specific laws that apply. That doesn't mean lawyer fees are random. Most states have professional conduct rules governing attorney fees, and many of those rules are influenced by the American Bar Association's Model Rule 1.5. The basic idea is that fees must be reasonable. What is considered reasonable can depend on several factors, including the lawyer's experience, the complexity of the case, the time required, and the work involved. Also, the rules can also vary depending on the type of case. In other words, a lawyer cannot use the same fee arrangement for every client and every situation. The most common of these is hourly billing. Straightforward, on paper. The lawyer charges for the time they put in, every phone call, every hour of research, reviewing documents, drafting paperwork, showing up in court, sitting across from you in a meeting, all of it, billed by the hour. The rate can vary significantly. A new attorney in a small town may charge far less than a senior lawyer practicing in New York or Washington, D.C. In hourly billing, the risk is mostly on the client. Win or lose, the lawyer gets paid. That is one reason hourly billing is commonly used in criminal defense, business disputes, and regulatory matters. Then there's the flat fee model, a different philosophy altogether. Here, the lawyer charges one fixed price for a specific service. No clock running, no surprises at the end of the month. This works best when the task is relatively predictable, such as a simple immigration filing, business registration, basic contract, or uncontested divorce. The client knows the cost upfront. However, if the matter becomes more complex than expected, additional charges may apply. That is why the fee agreement is important from the start. Another common arrangement is the retainer, though it isn't always what people assume it is. A traditional retainer simply secures the lawyer's availability on call when you need them. An advance fee retainer works differently. Money goes into an account up front, and fees get deducted as the work gets done. Retainers are often used by businesses, family law clients, and others who need ongoing legal support. For the client, it secures access. For the lawyer, it secures payment. There are also hybrid fee arrangements. For instance, a lawyer may charge a reduced hourly rate and receive an additional success fee if the case ends favorably. This allows the lawyer and client to share some of the financial risks. Then there's fee shifting, the exception, not the rule. In certain cases, a statute, a contract, or a court rule steps in and shifts that burden, requiring the losing side to cover some or even all of the winning side's legal fees. You may see this in civil rights, consumer protection, employment, and environmental cases. These cases may not always bring huge money, but they can still serve an important public purpose. Then comes the most famous fee arrangement in personal injury and mass tort litigation, the contingency fee. This is often called the no-win, no-fee model. Instead of charging up front, the lawyer takes a percentage of any money recovered. If the case succeeds, the lawyer gets paid. If not, the lawyer may receive no legal fee at all. That changes the entire risk equation. A lawyer may spend months or even years reviewing records, gathering evidence, and negotiating with defendants without any guarantee of payment. That is why contingency lawyers are selective. Before taking a case, they often evaluate the injury, the evidence, the defendant, the potential recovery, and the expected cost of litigation. It also helps explain why some personal injury and mass tort lawyers can earn millions of dollars from successful cases. But there is another detail that often gets overlooked. Fees are not the same as costs. Fees compensate the lawyer for legal work. Costs cover expenses such as court filings, medical records, expert witnesses, and trial preparation. The bigger point is that money is not just part of the legal system. It influences which cases get filed, which clients find representation, and whether a law firm can afford to take on a powerful company in a long legal battle. A lawyer billing by the hour may earn steadily across many cases. A contingency lawyer may earn nothing for years, then earn millions from one major settlement. There's no single way lawyers get paid, because there's no single type of legal case. Every arrangement you've just heard about didn't appear by accident. Each one evolved to solve a very specific problem. Without them, many people could never afford to bring a lawsuit in the first place. The system is far from perfect. Legal representation can still be expensive, and some cases are simply too risky for a law firm to pursue. But one thing remains clear, no matter which arrangement is on the table. Before a lawsuit ever becomes a courtroom battle, it first has to make financial sense. And that single reality, more than talent, more than the strength of a case, decides who gets represented and who gets a real chance at justice in America.